Chapter 33, Equity Pleading, Proceedings after filing of Bill, Sec. 195. The subpoena. Upon the filing of the bill with the clerk of the proper court, who enters the cause, by its title upon the appearance docket, endorsing thereon the day of filing, the clerk then upon the application of the complainant or his solicitor, issued a subpoena. The conclusion of the bill, the groundwork, is the prayer for a subpoena, adding a statement of the purposes for which the writ is required, which in ordinary bills, is that the defendant may be compelled to attend, in order to answer distinctly the several points in the bill, and 2, that upon a view of the case, the court may interpose its authority to prevent, or redress the wrong, or it may decide upon the ultimate claims of the parties, and enforce its decree by process of execution. The subpoena in Chancery is a mandatory writ, or process, issuing under the general seal, directed to a party, summoning him to appear, under a penalty, subpoena centrum librarum, to answer to such things as are objected to him, either on any day certain within the term, which is the ordinary return, or during the vacation, immediately. Sec. 196. The appearance. Upon the return of service of the subpoena or upon due proof of notice having been given, the defendant is considered in court, and may be proceeded against accordingly. When served with a subpoena, he is to put in his appearance after the return of the writ, which is a voluntary appearance, or such appearance may be compulsory, by means of the process for that purpose. The defendant is then bound to file his plea, answer, or demurrer, within the time prescribed. The Chancellor, in England, had no power to render a decree, either pro confesso, or otherwise, until an appearance was effected on the part of the defendant. The appearance consisted of an application, by the defendant in person, or by his solicitor, to a clerk of court to appear for him, leaving with the clerk a note in writing, informing him of defendant's appearance. The statutory modification of the old Chancery practice in the states of this country was such that the court could, if the defendant failed to file his plea, answer or demurrer, in its discretion render a decree pro confesso. Sec. 197. Demurrers. If the defendant wishes to attack the legal sufficiency of the bill, he may file a demurrer as in common law procedure. They were, as in the common law, either general or special. General where no particular cause is alleged, special, where the particular imperfection is pointed out. The former may be resorted to, where the pleading is defective in substance, and the latter, where the objection is only to the form of the pleading. A defendant may demur to part of a bill, plead as to other part, and answer the residue. As a demurrer relies upon matter apparent on the face of the bill, so much of the bill as the demurrer extends to, is taken as true. A defendant cannot demur and plead, or demur and answer, to the same part of the bill, for the plea or answer overrules the demurrer. When a demurrer to the whole bill was overruled, the defendant by leave of the court, could put in a demurrer less extended. If the defendant demur and answer, the plaintiff could not proceed on the answer, until the demurrer had been argued or disposed of. The demurrer being filed with the clerk, and the complainant having joined in demurrer, the cause was ready for hearing. Sec. 198. Of the plea. A plea in equity was a method of defense, to the whole or some part of the bill, showing or relying upon a fact or facts, not apparent upon the face of the bill, and constituting a single point of defense, as cause why a particular suit, or that part to which the plea is directed, should be dismissed, delayed, or barred. A plea is distinguishable from an answer in that its office is not to give any discovery, it is in fact an excuse for not answering. A plea is also to be distinguished from a demurrer in that the latter is directed to defective matter contained in the bill itself, while a plea relates to foreign matter, to discharge or stay the suit. As that another bill for the same cause is pending, a plea is interposed for the purpose of setting up some matter which abates, suspends, or creates a bar to the suit, or to the part to which it applies, and avoids the necessity of interposing a defense to the merits, and does away with the discovery asked for and the expense of going into the evidence. Matters in abatement are such as lack of the requisite citizenship, want of corporate capacity, want of capacity to sue, or pendency of another action. It may set up prior adjudication. The filing of numerous pleas is not generally permissible, only one being allowed by the express permission of the court. If filed with such permission, the defendant may file a motion to compel the defendant to elect upon which he will stand. The plea was sometimes allowed to stand for an answer, if a plea is bad in form only, but good in substance, as to the whole, or any part of the relief sought by the bill, and was not pleaded in bad faith. It was permitted to stand as part of the defendant's answer, or the defendant was permitted to insist upon the same matters in his answer. If a plea constituted a full defense to a particular part of the bill, and was disallowed on some technical defect, or informality in the manner of pleading, the court permitted it to stand for an answer, and prohibited the complainant from calling for a further answer by exceptions to that part of the bill. Pleas were divided into 1. Affirmative pleas, 2. Negative and 3. Anomalous pleas. The affirmative plea is the one usually pursued in equity as the pure and normal type, the logic of which was to bring on the record essential matters of fact omitted in the bill. If the bill suppresses the fact that there has been a payment or a release, or a former adjudication, or that the limitations has run, or that any other statutory or equitable defense exists, such matters may be brought in by the plea. A negative plea in bar denies some essential allegation of the bill, or some averment on which the case rests. The logic of such a form of plea is that if the complainant's rights depend on false allegations of a single essential matter of fact, the defendant should not therefore be required to answer all charges in the bill, if the suit may be ended by a plea of denial of the one essential fact. A plea is anomalous if a bill anticipates a defense, and without admitting its truth, replies to it affirmatively, and the defendant wishes to set up the defense by plea. It is obvious that he must traverse the anticipatory replication, for otherwise, in the event of issue being taken upon the truth of the plea, the affirmative replication will be admitted to be true. A negative rejoinder, therefore, must be incorporated with the affirmative plea. Being partly affirmative and partly negative, they are distinguished by the name of anomalous pleas. If the defendant should not be prepared to deny the truth of the affirmative replication, and should wish to set up an affirmative answer to it, of course both branches of his plea would be affirmative. If an anomalous plea be put in issue, it will be seen that each party has something to prove, namely, the defendant his affirmative defense, and the plaintiff his affirmative replication. Sec. 199. The answer. If the defendant has no just cause of exception to the bill, he must proceed to answer upon oath all the material allegations contained in the bill, by confessing and avoiding, or traversing and denying, each of them separately and distinctly, according to the best of his knowledge, recollection, information and belief. The answer must admit or deny all facts in the bill, with all their material circumstances, even though no special interrogatories are contained in the bill for that purpose. He must answer specially the specific charges in the bill, a general answer though amounting to a full denial, not being sufficient. He must answer directly and precisely every material allegation, and not by way of negative pregnant. It appears that in the earlier history of Chancery practice the answer of the defendant was not in writing, it being the custom to personally appear in response to the subpoena submitting to an examination orally by the Chancellor. The appropriate way of designation in earlier periods was the taking of the answer of the defendant. If he lived in London he was examined on the bill and interrogatories by the court. At a later period the duty of drawing the answer was delegated to counsel for the defendant. In course of time it came to be the regular practice for the solicitor of defendant to draw up the answer of the defendant, whether the defendant lived in London or in the country. The practice of taking the answer before commissioners did not generally obtain in the federal courts in this country. If a defendant resided beyond the sea, the practice was to issue a dedimus potestatum, we have given authority, to a commissioner to take his answer. The answer always began with its title, specifying which of the defendants it is in answer of, and the names of the plaintiffs in the cause in which it is filed. Where there are several defendants they should answer jointly, unless their titles are different. The defendant was required to sign and swear or affirm to his answer, which was required to identify the instrument which he had thus sanctioned by his oath, for the particular purpose of rendering a conviction of perjury more easy. Though the answer should be signed and sworn to by the defendant, this may have been waived by the complainant, by the filing a replication without objecting for want of verification. A defendant may not pray for anything in his answer, but to be dismissed from the suit. If he has any relief to pray, or discovery to seek against the complainant, he must do so by a bill of his own, which is called a cross bill. The two bills, the original and cross bill, are then usually brought to hearing together, and are considered as forming in fact but one cause. Sec. 200 of interlocutory steps and orders before filing of replication, motions and petitions. Upon the filing of the answer to the bill, the complainant then had to consider what next step he shall take in the suit. If the answer admitted all material allegations, the hearing may proceed at once. If the answer traverses or denies the substance of the bill, the complainant must proceed to join issue by replication, and prove his case by the examination of witnesses. The interlocutory orders and motions were exceedingly numerous, technical and arbitrary. They were so unconnected and artificial, as not to be susceptible of being arranged into a connected system. They could not be studied so well except by actual practice and observation in the actual work in an office or in the work of the court. These rules, orders and motions were controlled almost exclusively by regulations of court to facilitate the administration of justice. The orders were either common or special, and the applicatæ for the same were made either by motion or petition addressed in writing to the Master of Rolls, which when engrossed were delivered to the secretary of the judge to whom the same may be addressed. Motions not of the common order could only be made upon notice to the adverse party. Motions were always made in open court, whereas petitions were in some cases a private and ex parte proceeding. The application for a special order, whether by motion or petition, was usually supported by affidavit of the facts relied on. If the facts were doubtful or complicated, the court would direct a reference to a master, to inquire into the particulars, and report accordingly. Sec. 201. Same reference to master. A reference was an order of court, whereby exceptions, contempts, irregularities, matters of account, the choosing of guardians, receivers, purchasers under a sale directed by the court, were referred to a master to examine and make report of to the court, so that the court could make an absolute order therein. Sometimes the master was empowered to finally determine or settle the matter. But generally when he reported his opinion on the facts, his powers as an instrument of justice ceased, all reports by him being founded either on matter of fact, or matter of opinion. All reports by the master must be confirmed by the court. Exceptions may be filed to the report of the master which are in the nature of special demurrers. Sec. 202. Interlocutory orders, the injunction, and other restraining process. It frequently happens that an interlocutory order by way of injunction is necessary before further steps are taken. Injunction is the most efficient process in the law. It is an instrument in the hands of the Court of Equity to enable it to carry out the powers of administering the law according to the law of equity. Preventive justice as administered by a Court of Equity, by the aid of its process of injunction, is the most important subject of jurisdiction possessed by any court. There were two classes of injunction: 1. The ordinary injunction, and 2. The common injunction. The former, like the decree, was decided on the merits, while the common injunction is one granted as of course, until answer is filed, and further order. The writ of ne exeatrigno, that he leave not the realm, was originally to restrain one from leaving the kingdom, but was afterwards used to prevent one owing a debt from going out of the jurisdiction, and issued only on an equitable demand. The object and design of the writ as used in courts of Chancery, is to hold the party amenable to justice, and to render him personally responsible for the performance of their orders and decrees. Sec. 203. Amending the bill. The complainant was at all times before replication was filed, at liberty to amend his bill. As a matter of course, amendments were regarded as a portion of that interlocutory power exercised by courts of equity to facilitate them in the administration of justice. They were allowed only when the bill was defective of parties, or in the prayer for relief, or in an omission or mistake of a fact connected with the substance. Facts known to complainant at the time of filing the bill could not be brought in by amendment except upon good excuse being given for the omission. Great latitude was always allowed as to amendments, however, where the case required it, especially where the bill was amended after demurrer. An amendment, by adding new parties, was usually permitted at any time. even at the hearing of the cause, on the ground that none are bound by the decree except those parties to the suit, it being sometimes difficult to ascertain who were necessary parties to make a decree effectual. But no new charge could be introduced, nor no new facts could be put in at this time. If the bill was for discovery merely, new parties were not permitted to be thus brought in, because no decree was sought, and no objection could be raised to it for want of parties. Sec. 204. Exceptions to answer. If the defendant does not, in his answer, admit or deny all the material facts and allegations of the bill, according to the best of his knowledge, information and belief, the answer is said to be insufficient and may be accepted to by the complainant on that account. As a general rule, exceptions may not be filed after a replication, although under special circumstances the court may permit the replication to be withdrawn and the exceptions received. If upon hearing of the exceptions the answer is adjudged insufficient, the defendant must file a further answer within a specified time, or the bill will be taken as confessed. The second answer may likewise be accepted too. Exceptions may be taken to an answer for impertinence or scandal. Exceptions to an answer were referred to a master to expunge such matters as were improper. Sec. 205. The replication. If the parties proceed to hearing on bill and answer only without a replication, the answer will be taken to be true in all points, and no evidence can be received to contradict the answer, except matters of record, to which the answer refers, and is provable by such record. The replication is necessary when there has been no exception to the answer, and the complainant does not have the case set for hearing on the bill and answer. The replication is a formal pleading merely, which was required by the ancient practice in Chancery, and it has not been dispensed with in the federal courts. This form of pleading was borrowed from the common law practice. The courts sometimes permitted a replication to be filed, after a cause had been set down for hearing, when it had been omitted by accident. It was formerly the practice to reply specially to an answer offering new matter. This led to a rejoinder, surrejoinder, and surrejoinder. The inconvenience, delay, and unnecessary length of pleadings, arising from these various allegations on each side, occasioned an alteration in the practice, and special replications, with all their consequences, fell into disuse. Sec. 206. Examination of witnesses and proceedings preparatory to a hearing. In England, as a general rule, no testimony could be taken, until the defendant had appeared to rejoin gratis, or until the return of a subpoena to rejoin, and service on the defendant or his clerks in court, Junior. 474. Or, in other words, until the cause is regularly at issue. This was done by examination of witnesses, and taking their depositions in writing according to the manner of civil law. A court of chancery had no authority to hear witnesses viva voce, their examination had to be put in writing. The examination was either in the examiner's office, if the witnesses were near enough, or before a commissioner specially appointed for that purpose when the witnesses were at a distance. Anciently all examinations were taken before the Master of Rolls in person. But when the business began to increase, the business of the examination fell into the hands of sworn clerks of the Master of Rolls, thence called the examiners. It was thought too much to trust them with the direction as to what questions were to be asked, so that it became the practice to frame and file interrogatories in writing, on behalf of either party, which were to be propounded to the witnesses. The manner of examination was regulated by various rules and orders of court to ensure fairness and impartiality, allowing no undue advantage to be taken on either side. The examiner had to proceed with impartiality and caution, and was required to decide as to the competence of the witness, and the relevancy of the interrogatory. The English practice in this matter was almost entirely abolished by some of the states in this country prior to the Code, being regulated by statute and rules of court. Depositions could be taken in any part of the United States at any time after the commencement of the suit upon proper notice. All depositions were filed with the clerk, and were opened by him at the request of either party or his counsel. A witness could be examined viva voce, at the hearing for a particular purpose, as to prove exhibits, but, in general, all the proof in the Chancery cases, was reduced to writing, and was properly taken before a master in Chancery, though it could be taken in the same manner as depositions in cases at law. If the opposite party desires to cross-examine any witness, he may do so by filing cross-interrogatories, leaving a note with the examiner for that purpose. Cross-interrogatories should be lodged with the examiner before the direct examination is closed. The student will do well to observe the distinction of the rule of admission of parties as witnesses between courts of equity and law. It was formerly the rule in Great Britain and in most of the states of the Union, before the change in the common law rule in this respect, that a party to the record could not be permitted to testify in his own favor if objected to by the opposite party, nor be a witness against himself if he objects. A defendant could be examined as a witness provided it be only to points in which he is not concerned in interest. This could not be done except by special order. Where a party is examined before a master in relation to his own rights, the examination is in the nature of a bill of discovery. He may not be cross-examined by his own counsel, nor can he give evidence in his own favor any further than his answers are responsive to questions put to him. He may rebut or explain inferences arising from his answers. Sec. 207. Law governing competency of witnesses in federal courts. The competency of witnesses in the federal courts was formerly governed by the rules prevailing in the Chancery courts of England. But this was changed by statute, as it has been changed in the several states, to the effect that neither party shall be disqualified as a witness in any civil action because he is a party to or interested in the cause to be tried. Sec. 208. Method of taking testimony in equity in the federal courts. Testimony in equity cases in the federal courts may be taken, 1. By oral examination before an examiner under Equity Rule 67, 2. By deposition taken on written interrogatories and commission issued in accordance with the ancient practice of the court, 3. By deposition taken on notice under Section 863, of the revised statutes. Depositions may also be taken to be used in the federal courts according to the mode prescribed by the law of the state where the court is held. The practice of examining witnesses orally before an examiner originated with the amendment of 1861 to Equity Rule 67, and is similar to the course of proceeding in the English Chancery. In 1891 the Supreme Court amended Rule 67, which in substance is based on the ancient method of examination before the examiner in the English Court of Chancery. The rule is that upon notice either party may take testimony before one of the examiners of the court, or before an examiner specially appointed by the court. Sec. 209. Of setting down a cause, and a subpoena to hear judgment, when the pleadings are concluded, and the trial of matters of fact at an end, by the publication of depositions. The next business is to obtain the judgment of the court on the points at issue. For this purpose the cause must be set down for hearing, and process of subpoena served on the opposite party, to attend and hear judgment. The manner of hearing a cause was as follows. The junior counsel on both sides severally open the pleadings, wherein they briefly state the substance and prayer of the bill, and the nature of the defense, after which the complainant's leading counsel states the case, and the points in issue, and submits his arguments upon them to the court. The proofs are then read, and then the counsel on each side address the court. Sec. 210. The decree. The court having heard the arguments on both sides, and the evidence by which they are sustained, proceeds to give its sentence, or decree. The decree is defined to be the order of the court, pronounced on hearing and understanding all the points in issue, and determining all the rights of the parties to the suit, according to equity and good conscience. There is a similarity in the nature and effect of a decree and a judgment at law. They are both the determination of the law, upon some matter in controversy between the parties. A judgment at law may be far more limited in its operation and effect than a decree. It may be confined to a restoration of something, or to the recovery of damages for an injury suffered. A decree on the other hand may be molded and formed to meet every variety of circumstances which are the subject of controversy. It may, as Mr. Justice Story states, vary its adjustments and proportions, so as to meet the very form and pressure of each particular case in all its complex habitudes. Sec. 211. Of the Bill of Review. Bills of review are in the nature of a writ of error, at common law, and are brought to review, alter or reverse decrees in Chancery. According to the earlier mode of practice, whether a bill of review could be heard was entirely in the discretion of the court. It was permissible upon two grounds, viz., first for an error in law appearing on the face of the decree, and secondly, on the ground of newly discovered evidence. The second ground was analogous to a new trial at law, and some of the principles regulating new trials will apply to a bill of review. In England the rule was that on a bill of review for errors of law, the court could not inquire into the sufficiency of the proof of any fact, but the original decisions of the court upon the effect of evidence was considered conclusive. This rule seemed to be founded upon another principle, that the final decree must present a history of the case and must contain a full statement of all the facts on which the decision of the Chancellor was founded. In the earlier Chancery practice in this country an entirely different practice prevailed in some states. Errors could be assigned upon the record generally, and the court would examine the whole case, and decide as if the matter were open before them, in the same situation as when the decree was pronounced. It was not necessary that the facts proved, or principles decided, should be inserted in the decree. The court, upon a bill of review, examines all the exhibits and proofs in order to determine whether the original decree be erroneous or not. The bill of review had to recite the substance of the original bill and answer, exhibits and depositions, and the proceedings thereon, as well as to state the points in which the party conceives himself aggrieved. No error would be examined except that assigned in the bill. It was discretionary with the court to give leave to file a bill of review on the discovery of new evidence. The rule was invariable that a bill of review upon a matter of fact must be upon special leave of court, and upon oath of the discovery of new matter or evidence which hath come to light after the decree, and could not possibly be heard or used at the time when the decree passed.